Good afternoon, everyone. This is John Bonifaz with Free Speech for People. Thank you all for joining us for this briefing today on our fight to challenge foreign corporate influence in our elections. We're pleased that you all could join us today for this discussion on this critical reform on campaign finance. We began this work a few years ago, and it's now taken on new momentum this year, building off of a victory we won in Seattle, Washington in January of 2020, which, with our partners in Seattle, passed via the Seattle City Council a model bill that we helped to draft, which bans foreign corporate spending in Seattle elections. We also had won an earlier victory in St. Petersburg, Florida, on this model bill, and the bill is now pending in 7 states across the country. We're going to hear today from our legal director, Ron Fine, and our campaign director, Alexandra Flores Quilty, about this work. But first, I wanted to hand it over to Oski Buckley, our director of administration and finance, who will show us a short video that we've produced, 3-minute video on this work that we're engaged in across the country. Oski?
Great, thank you, John, and thank you everyone for joining us today. So I'm just going to set up the video now.
And the real challenge I think we face today with our democracy is that big money interests are drowning out the voices of ordinary citizens. The threats of super PAC spending and of foreign corporate money are at the doorstep of St. Petersburg. And St. Petersburg has the opportunity to protect and defend its democracy here with this proposed ordinance, and to set an example for the nation of what we can do to reclaim our democracy.
Massachusetts currently has a bill pending in the Massachusetts State Senate that we worked on with Common Cause of Massachusetts. Obviously, the premise of this law is not xenophobia. It's not to discourage foreign investment. What it's to do is to ensure democratic self-government.
The fear is, and the real danger is, that someone like me might fall prey to big money able to come in and solve my campaign spending woes with large checks. But those large checks would absolutely come with some spoken or unspoken deliverable.
Why so much interest on the part of these super PACs, the corporations that are funding them, for the outcome of these Seattle City Council elections?
It was a remarkable pace of corporate political spending in Seattle that outstripped anything that had been seen before. And a lot of it was driven by Amazon.
Here, the issue is not the threat, it's here and now. Seattle is already experiencing this flood with respect to the corrupting influence of big money into super PACs and with respect to foreign influenced corporate spending.
Our U.S. Constitution is very clear that our government should be governed by the people of this country, and it is fundamentally about preserving our democratic process and protecting our Constitution.
The corporations that are foreign influenced aren't just a collection of citizens. They are a collection of potentially citizens, non-citizens, foreign governments. And so with regard to political spending, the rights that flow to citizens don't necessarily flow to foreign actors.
So in Maine right now, we are facing the Central Maine Power Corridor. But it's owned by Iberdrola, which is a Spanish company whose major investors aren't even from Spain. And they are dumping huge amounts of money, like just ridiculous amounts of money.
We're talking about corporations that are, ultimately deriving their money and are being run in the interests of, to varying degrees, foreign investors. And what that means is that, the views of ordinary Maine citizens are really getting relegated to sort of pawns in this larger battle between corporate interests.
There are many other things that have to happen to reform our system of big money in elections, but this is a critical way for the American people to fight back and reclaim our democracy. Great, thank you, Oski. So we're now going to hear from Ron Fine, our legal director, to discuss further this work and this model bill.
Thank you. I'm Ron Fine. I'm the legal director here at Free Speech for People. Citizens United opened the door to massive political spending by corporations in federal elections, and a follow-up decision from the Supreme Court in 2012 did the same for state and local elections, and about half of the states had banned corporations from spending in their elections before that decision. It's hard to know exactly how much total corporate money has flowed into our elections because a lot of it is routed through nonprofits and trade associations and other channels that don't require disclosure. And in fact, more than half of all companies on the Standard & Poor 500 list don't disclose how much they give to 501c4 nonprofits. But here's what we do know. We do know that at the federal level, corporations have spent many hundreds of millions of dollars, usually via super PACs, over the past decade in federal elections. The largest donors on that list tend to be oil and gas companies like Chevron and NextEra Energy. This money does go to help both Democrats and Republicans, but not equally. According to the Center for Responsive Politics, 87% of corporate contributions to super PACs go to conservative groups. At the state and local level, corporate political spending can be even more impactful. In 2016, Airbnb responded to the New York legislature's growing interest in regulating its industry by funding a super PAC with $11 million to influence New York State's legislative races. State ballot initiatives can see even huger expenditures. In 2020, the most expensive ballot initiative in California history, Uber and DoorDash, spent $200 million on Prop 22 to overturn recent legislation passed by the California legislature regarding treatment of their drivers as employees. And right now in Maine in 2021, competing sets of corporations are dumping tens of millions of dollars into a ballot initiative about an electric transmission project. And we're even now seeing big corporate political spending at the municipal level. In 2016, Uber and Lyft spent over $9 million on a ballot initiative in the city of Austin, Texas. And in 2019, Amazon dumped $1.5 million into a super PAC with the goal of unseating the entire Seattle City Council. So this is the phenomenon of corporate political spending, but whose money are these corporations spending? And when they do spend money to influence our elections, when the executives spend that money, who has influence over those executives? In 2016, Federal Election Commissioner Ellen Weintraub made a perceptive observation in a New York Times op-ed. You see, the Citizens United decision described corporations as associations of citizens. Justice Kennedy used that phrase 3 times in his decision. But that doesn't apply to most multinational corporations. Overall, foreign investors own about 40% of US stock. That's more than all retirement accounts in all US households combined. In some cases, it's widely distributed. It might be that a large number of foreign investors combine to own a substantial percentage of stock, but in other cases, it can be quite concentrated. For example, just a few weeks after spending millions of dollars in the Austin election, Uber disclosed that the Kingdom of Saudi Arabia had just invested $3.5 billion in the company, giving it 5% of equity and a seat on the board of directors. Or take NextEra Energy, which I said earlier is one of the largest federal corporate spenders, and it's already dumped $5 million into that main ballot initiative. NextEra is owned in substantial part by investors from Europe and Asia, and including a significant position held by the Norwegian State Sovereign Wealth Fund that it derives from its oil revenue. And these aren't cherry-picked examples. You look at any S&P 500 corporation, and there's a good chance that it's owned in substantial part by foreign investors. But here's the problem. Foreign entities aren't supposed to be able to spend money or influence somebody else's spending of money to influence US elections. So for decades, federal law has prohibited foreign individuals and entities from spending their own money in US elections. So the Saudi Sovereign Wealth Fund or the European investors behind NextEra cannot spend their own money in US elections, federal, state, or local. That is already illegal. And furthermore, that law was upheld against a constitutional challenge just 2 years after Citizens United. In a case that not many people know about, called Blumen versus Federal Election Commission, the Supreme Court affirmed a lower court decision that was written by Brett Kavanaugh, then a lower court judge, now a Supreme Court justice, in which he upheld the federal ban on foreign entities or individuals spending directly in federal elections. And as Justice Kavanaugh said, it's not even about corruption, it's about the basic preservation of democratic self-government. But when a multinational corporation puts millions of dollars into a super PAC, whose money are they spending? Corporate governance experts and corporate lawyers and courts talk about a concept of shareholders' residual equity. It's an abstraction, and it rarely actually comes to this in practice. But in some sense, the money in a corporation's treasury belongs to the shareholders. So in some cases, especially if it's a company that's privately held, this is obvious, like when the Saudi government invested $3.5 billion in Uber. But it's also true of older publicly traded companies like Chevron, where the current shareholders bought their shares on the market and are not the original investors. Now, I'm not talking right now about whether a company like Chevron sets up an employee PAC where its own executives contribute their own money in limited amounts. I'm talking about the money in Chevron's corporate treasury, the money that it gets from selling oil. That money ultimately belongs, in some sense, to the investors. And that includes the foreign investors. And these foreign investors cannot spend their own money directly on US elections. But under current law, the corporation can spend it for them. It's not even just that. It's not just that the corporate money belongs to the foreign investors in part, but also large investors, whether they're US based or foreign, have influence over corporate decision making. This isn't unique to foreign investors, but whether it's through the formal procedures of so-called corporate democracy or through informal influence mechanisms, major investors can influence how corporate executives make their decisions. Doesn't mean they can dictate every decision. Sometimes they have more influence, sometimes less, but they can certainly exert influence. And when it comes to decisions about US political spending, this raises the question of what Justice Kavanaugh called protection of democratic self-government. And what can surprise some people who are unfamiliar with corporate governance is that an investor can exert this influence with a relatively small percentage of equity. Some people would say on a first guess that in order to exert that type of influence, you'd need more than half of the stock, so you could control every vote. Maybe on a second guess, they would say a large minority, like 20% of stock would be enough. But in fact, investors and scholars in the corporate world agree, and it's also not a matter of partisan dispute, that investors can exert influence with much, much lower levels of ownership. Let's take shareholder resolutions as an example. Until this past fall, the federal rule was that an investor with 1% of shares could force a resolution to be voted upon by shareholders. That was the rule until the fall, but then everyone agreed that the threshold should be lowered, because in a major publicly traded corporation, 1% is actually an enormous holding. It's billions of dollars, and many incredibly influential investors don't hold anywhere near 1%. As an example, over the past few years, the New York City Pension Fund led multiple successful shareholder proposal campaigns, despite owning less than 1% of every single one of the targeted companies. In fact, if you own 1% of shares, you don't even need to bother with a resolution to have influence over the company. You're probably in the top 10 shareholders, and you can just call the CEO on the phone if you want his or her attention. And the thing is, the CEO knows that. So even if that investor doesn't make a call, executives act in the shadow of that influence at all times. So our legislation is designed to tackle the issue of influence in the context of corporate political spending. We've already succeeded in helping pass laws in St. Petersburg and Seattle. There's legislation pending in 7 states, soon to be 8, and in Congress. Along the way, we've refined the model, and the pandemic did slow our forward progress somewhat, but Fortunately, we were able to help pass the Seattle legislation in 2020. And in working with the Seattle City Council, we marshaled outside expert testimony from Federal Election Commissioner Weintraub, from Professor Lawrence Tribe of Harvard Law School, a leading constitutional expert, and Professor John Coates of Harvard Law School, a leading corporate law expert, who is now the Director of Corporate Finance at the Securities and Exchange Commission. Commissioner Weintraub and Professor Tribe explained why the bill was constitutional under both the Citizens United decision and the Blumen decision. Professor Coates explained how it worked mechanically, and I'm not going to bore you with the implementation details on this call, but Professor Coates explained how it would work for a publicly traded corporation. So I want to talk now about the bill that is pending in New York State. It's called the Democracy Preservation Act, and sponsored by Senator Michael Gianaris, who is the Deputy Majority Leader. The New York bill defines a class of business called a foreign influenced business entity. And this type of business is banned from spending money in all state and local elections. Now, that forms of spending money from which it's banned includes candidates or ballot measures. It includes contributing to super PACs. And there are also safeguards to prevent routing money through 501c4s or other secret money groups. So what is a foreign influenced business entity? The bill defines it as a company that is owned 1% by a single foreign investor or 5% by multiple foreign investors. These thresholds cover 98% of the S&P 500. Now, as for small cap, but still publicly traded corporations, for example, a company that might be traded over the counter, it would apply to about 1 in 3 of those. But as to the vast majority of small, local, or family-owned businesses, it would have no impact at all. In addition to the bill in New York, this year we've also worked on bills in Massachusetts, Colorado, Maine, Minnesota, Hawaii, Oregon, and New York City, and a bill soon to be introduced in California. Furthermore, as the video noted, Senator Warren and Representative Jayapal have added a provision doing this to their Federal Anti-Corruption and Public Integrity Act. Now, not all of these bills will pass this year, of course, but even those that don't will help lay groundwork for the following year. Our leadership on this issue has benefited from partnerships. In both St. Pete and Seattle, we worked with fantastic local partners. In a few places, we've worked well with Common Cause chapters, and at the overall project level, we've strategically partnered with the Center for American Progress. I want to leave you with a few last points as I wrap up. People sometimes ask, is this about corporate political spending or is it about foreign influence? And in some sense, it's about both. What it's certainly not about is immigrants, documented or undocumented. It's about Amazon and Uber and Chevron and Comcast and their multi-billion-dollar foreign investors. These are not the associations of citizens that Justice Kennedy talked about in Citizens United. As the CEO of ExxonMobil once said, and this is an actual quote, "I'm not a US company and I don't make decisions based on what's good for the US." The goal of our project is to demonstrate that the public at the local, state, and ultimately federal level can protect our most basic democratic self-government from the depredations of multinational foreign influenced corporations. Thank you.
Great, thank you, Ron. Our next speaker is our campaign director, Alexandra Flores Quilty, who will talk in particular about our campaign in New York State. Alexandra?
Thank you, John. I am excited to share more about a version of this model legislation that is currently proposed in New York State. Over the past decade, foreign influence corporations have spent many millions in New York's elections. When a state constitutional amendment was on the ballot, gambling companies spent $1.5 million to influence the outcome. Those gambling companies have major investors in Malaysia and elsewhere. In another example that Ron named previously, Airbnb spent $11 million in New York's 2016 legislative races. Airbnb is partially owned by a Russian oligarch's venture fund. This legal loophole for foreign invested corporations overwhelms the voices and votes of New Yorkers. It poses a threat to the integrity of elections and our democracy. However, in New York, our model legislation has been introduced by Senator Michael Gianaris in the New York State Senate for the current legislative session. The Democracy Preservation Act, S1126, would amend New York election law to prohibit corporate political spending by foreign influence business entities in New York's state and local elections. A foreign influence business would be prohibited directly or indirectly from contributing to candidates, parties, or committees that include super PACs, or from engaging in its own direct election spending. So how is this enforced? This law would require that every business entity that makes an expenditure or contribution for political purposes must file a statement of certification that the business entity is not foreign influenced. This statement would require the signature of the business's CEO under penalty of perjury and filed with the State Board of Elections. It is our assessment that this is an effective way to enforce the law. The bill is currently in committee and will be considered by the New York State Legislature in the current legislative session, which concludes on June 10th. So it will be decided in the next couple months. In all the cities and states that this model legislation has been considered, we have seen that grassroots support is a pivotal factor in the legislation passing. We are now working to build support with New York-based grassroots groups who want to see this corporate loophole in their state and local elections closed. We found incredible grassroots support and organizing in both St. Petersburg, Florida, and Seattle, Washington, where municipal versions of the legislation have successfully passed. In New York, Empire State Indivisible, which is one of the largest grassroots organizations in New York, has endorsed this bill. And other local grassroots organizations are currently in deliberation about endorsement as well. We are reaching out via our supporters list to ask New Yorkers to contact their New York State Senator, urging them to co-sponsor and pass the bill. And more grassroots organizing led by Free Speech for People, Empire State Indivisible, and other local organizations will continue while this bill is under consideration. In fact, tomorrow we will be announcing publicly a digital town hall around the Democracy Preservation Act. This town hall is for New Yorkers to learn more about the problem of this corporate loophole, how the Democracy Preservation Act seeks to close it, and how they can leverage grassroots power to support its passage. The town hall will take place on Thursday, May 13th at 7 p.m. via Zoom webinar and live stream. And the event is co-hosted by Empire State Indivisible and will feature remarks by Senator Michael Gianaris and Zephyr Teachout of Fordham Law School. The victories in St. Petersburg and Seattle have paved the way for this opportunity in New York State. If New York passes the Democracy Preservation Act, it will be the first state in the country to do so, and it will set a powerful precedent that many states will likely follow. So how likely is it that this bill will pass? Given the introduction of S1126 by Senator Gianaris as Deputy Majority Leader, in addition to the fact that Governor Andrew Cuomo previously supported a bill similar in principle, as well as the grassroots support that is only building in pressure, we are hopeful that New York will lead the way in the passage of this bill. New York is a state where corporations spend millions to influence elections. With the passage of the Democracy Preservation Act, it will put elections back into the hands of New Yorkers. Thank you.